This is Stacy Strong, and this is the third of the ASIL Private International Law Interest Group webinars. We're sorry to start a couple minutes late, as happens. We had a few technological problems, but we seem to be good. We have a fantastic program today with literally two of the giants of the private international law world. Of course, they're both very modest, so they don't like me to describe them as such. You have a description of the title of this particular presentation. It's the nature or natures of agreements on choice of court and choice of law. And our primary, or our first discussant, is going to be Professor Adrian Briggs of the University of Oxford. He's the Sir Richard Gosney Fellow and tutor at St. Edmund's Hall. He's been teaching in Oxford since 1980, and he primarily works in the area of private international law. In particular, within that field, he works on questions of civil jurisdiction and the effect of foreign judgments. Many of you are familiar with the fantastic treatise Dicey, Morris, and Collins, The Conflict of Laws, and Professor Briggs was an editor on that particular text for 15 years before coming out with his own perspective on this particular subject, which is called Private International Law in English Courts. I've read that. It is very, very long and very, very funny and very fantastic. When I say funny, it's because the first few pages, read them carefully, and you will find some very fun footnotes in there. The first edition came out in 2014, and he's also published a number of other books, including Civil Jurisdiction and Judgments, which is incredibly well known, very practical, and a must-have on any English barrister's or solicitor's desk. Our discussant is going to be Professor Simeon Simeonidis, who, again, should be very well known to all of you. His first two law degrees in both public and private law are from the University of Thessaloniki in Greece, and then his next two are from Harvard, an LLM and SJD. He is the former dean of Willamette University in Oregon, and he has taught at universities literally around the world and around the United States. I will not attempt to pronounce these because many of them are in French, and that is not my favorite second language. But he has taught all over Europe and the United States. He's published approximately 26 books and more than 120 articles, and again is most well known in the areas of conflicts of laws and comparative conflicts of laws. So because we're a little bit late, we're going to move forward. I believe that Professor Briggs is going to start off with presenting his perspective on this new area of law that he's working on. And then Professor Simeonidis will jump in, ask a few questions, give some additional perspectives, and then we should have time for all of you to submit a few questions. You will see on the right-hand side of your screen there is the opportunity to send a message. We will receive those and convey them to our discussants. So with that, I will pass it on to Professor Briggs.
Good morning, good afternoon. Can everybody hear me?
We can, at least, moderators.
That's good. That's an improvement. I've posted this paper, so if the transmission should go down at some point, people should be able to work out where I've got to, even if nothing else is working. The purpose of the paper, which is an interim report on work in progress, is to think about the nature, effects, and consequences of agreements which have as their object the jurisdiction of courts, and agreements which have as their object the law which will be applied to a relationship or to a dispute arising out of it. It aims to ask, and it aims to take steps towards answering whether agreements on jurisdiction and on choice of law are promissory or something other than promissory, why this matters if they're promissory, and how their legal validity is assessed, and how, if they're not promissory, their legal validity is assessed on that basis. The significance of this for an English lawyer is there are at least two dichotomies which need to be accounted for. One is the debate whether our answers to these questions are driven by the concerns of private international law or by the law of contract. Specifically, it asks whether reasoning which is derived from one area of legal thinking is applicable more or less unmodified when carried into another. A contract lawyer, for example, will tell you that these are contractual promises just like any other, and they are enforceable in just the same way as any other contractual promise is. Whereas a private international lawyer may say that the outward-looking principles of private international law and the concern for comity in particular is the primary motivation of the law, and that this may override the mundane, inward-looking concerns of the common law of contract. The second dichotomy reflects the fact that these questions can, at any rate before an English court, arise in relation to the common law and also within the context of the Brussels I regulation, Regulation 1215 of 2012 on jurisdiction and the recognition of judgments in civil and commercial matters, which is the statute which provides the starting point and quite often the finishing point for questions of jurisdiction which arise before the English courts. The specific question is how these agreements or these kinds of agreement function within the two very different legal frameworks in which they appear and take effect. Though the starting point is that of an English common lawyer, which is what I was born to be, the fact that English lawyers now have to work with legislation which is designed and made in Europe means that we have to accept that not everyone understands or appreciates or venerates agreements in the way that a common lawyer sometimes seems to do. This forced relationship which we now have with European law can make our less easy to describe, but it certainly adds a new perspective which is challenging and informative and ultimately useful. It means in particular there is a reason to reconsider the traditional, somewhat unthinking English approach which treats the existence, validity and enforcement of such terms to the full rigour of the private international law of contract, in which the proper law or the governing law plays a dominant role, and requires us to ask instead whether some of the effects that these clauses take operates outside this traditional contractual framework. I'll skip over what appeared as section B and move to the point on the paper which you have where I ask under heading C whether all contractual terms are promissory. Most people's first reactions are that they are, and that the few terms of a contract which are obviously not promissory are merely ancillary to promissory terms. It would be hard, after all, to argue that a definitions clause in a contract was promissory in nature, but in substance that's exactly what it is. For all a definitions clause does is to remove the definition or footnote function from each promissory clause and lodge it in the place where it most conveniently belongs. Liability limitation and exclusion clauses are probably the same. And though there are other sorts of clauses which test the theory, such as non-reliance clauses, contract terms are pretty much all promissory. But the law on jurisdiction and choice of law raises the possibility that some provisions in the contract should be seen to be effective without necessarily being promissory in nature. Our concern is therefore with the term in a contract by which the parties agree in relation to the jurisdiction of a court, and the term by which the parties express their agreement as to the law which is to serve as the proper law of their contract. What I want to think about is whether these terms are promissory, wholly or partly, and depending on the answers to that question, what the consequences will be. And with that introduction behind us, we can turn to pay more attention, first of all, to agreements which relate to the jurisdiction of a court. Now, it's long been the tradition of the English common law to see agreements concerning jurisdiction of courts as contractual in nature, and the nature of that contract as being characterised by the right-duty relationship, as Professor Hofeld might have said. This is intuitively appealing because such provisions are most infrequently included in contracts which spell out an elaborate set of rights and duties created and defined by the contract, which may relate to the performance and the behaviour of the parties during as well as after the performance of the contract. It's all part of the global agreement which the contract brings into effect. It has also tended to mean that the question whether the parties agreed to the jurisdiction of a court, in cases in which this contention is relevant, but disputed, or said to be overridden by some external factor or rule, is referred for decision to the law which governs the contract of which the provision is a term. The logic of this is clear enough, though whether that is enough to justify it is a completely separate question. But the characterization of terms as contractual also fits into the decisional framework applied by an English court when it is called upon to exercise a discretion related to the existence of its jurisdiction, such as arises on an application to stay proceedings which have been brought in the face of a jurisdiction agreement for another court. In the common law, as we understand it, jurisdiction depends only on service and only on service. And the question whether there was any agreement concerning the jurisdiction of an English court is irrelevant to the question whether service was made. But when it comes to a discretion not to exercise the jurisdiction which has been started by service, the question whether the parties came to an agreement relating to the jurisdiction of courts is a very significant factor. English courts are comfortable with contracts and with the legal position of parties who have made them. Issues which concern the formation of agreement or the validity or invalidity of agreement are easy enough to evaluate in contractual terms, and the court's instinct for relief is easily rested on a contractual analysis. All this has led English courts to analyse jurisdiction agreements as being contractual in nature and contractual in effect. It has led English courts to look to agreements on choice of court as creating rights and duties, and to see the primary role of the court as the enforcement of legally binding rights and duties. It is almost as though no one has ever suggested any other way of looking at things, and it has tended to mean that difficult questions are referred to the proper law of the contract in which the agreement is contained. However, there are other ways to agree, and there are other relationships which may come into being where there has been an agreement between parties. Not all agreements, or not every aspect of an agreement, will create rights and duties. This can come as a bit of a shock to English lawyers. However, a proper understanding of the jurisdictional relationship created by Article 25 of the Brussels I regulation illustrates beautifully the existence of this other category of agreement. The text of the article is, so far as material, as follows, and let me just read this very quickly. If the parties, regardless of their domicile, have agreed that a court or the courts of a member state are to have jurisdiction to settle any disputes which have arisen or which may arise in connection with a particular legal relationship, that court or those courts shall have jurisdiction unless the agreement is null and void as to its substantive validity under the law of that member state. Such jurisdiction shall be exclusive unless the parties have agreed otherwise. The agreement conferring jurisdiction shall be either A, in writing or evidenced in writing, ... And then if I go to point 5 of paragraph 25, an agreement conferring jurisdiction which forms part of a contract shall be treated as an agreement independent of the other terms of the contract. The validity of the agreement conferring jurisdiction cannot be contested solely on the ground that the contract is not valid. Three things in particular stand out when an English lawyer looks at that form of words. The first is that the article does not say that in order for it to be effective, the persons identified must have made the agreement in or by means of a contract, or that if they have made such an agreement, it operates as though it were a contract. This is important. If the question is whether a court has jurisdiction, it does not make sense for a court to have to try a central part of the case in order to decide whether it has jurisdiction. The idea that it must identify the law that governs the contract in order to decide whether it has jurisdiction to identify the law that governs the contract and so forth may be logical, but it is terribly over-engineered. It's far better to avoid that complexity and just ask perhaps whether there appears to have been a deliberate consensus on choice of court. The second thing that emerges from Article 25 is that the agreement of the parties does not create the jurisdiction. Rather, it provides the data with which the statute or the regulation, which is to say the law of the forum, establishes whether a court does or doesn't have jurisdiction. And the third is that what results from meeting the requirements of Article 25 and from Article 25 itself is not a relationship of jurisdictional right and duty, but one of jurisdictional privilege and liability. A defendant who had an immunity from being sued and whose opponent had no right to sue him in the designated court assumes a liability to be sued and grants his opponent a power to sue him in that court. Conversely, the agreement which results from the meeting of the requirements of Article 25 means that a plaintiff now has no right to sue the defendant where he is domiciled, and the defendant has an immunity from being sued there. And in the case of the non-exclusive jurisdiction agreement, the appropriate adjustments are easily made. If it is understood in this way, The relationship which the parties are brought into being by an agreement which conforms to Article 25 may be defied, dishonoured or departed from, but it cannot be breached. It cannot be breached because it does not, jurisdictionally speaking, impose a duty or confer a right. In the European context, this can be deduced from several decisions of the European Court, but the most important of these are those in which it was held that a national court designated by agreement between the parties could not adjudicate if the courts of another member state had been seized first, no matter how wrong that seizing may have been. And that an injunction ordered by an English court to restrain a party to a jurisdiction or arbitration agreement from suing in a non-designated court was unjustifiable. As one might say, where there is no remedy, there is no right, and if there is no right, no duty, one does not need to look to a contract or to any contractual version of a proper law to see whether such right or duty were created. It's unsurprising that the Brussels regulation groups together Article 25 and 26, which deals with jurisdiction by appearance, in a section entitled Prorogation of Jurisdiction. This prorogation may be made either before the writ, by agreement and in the form and format of Article 25, or after the writ, by appearance without immediate objection to the jurisdiction, in accordance with Article 26. In each case, the defendant agrees with the plaintiff to accept the jurisdiction of the court in which he is sued, in advance, in writing, after the writ, by conduct. These are both kinds of agreement, but they are not, jurisdictionally speaking, agreements of the kind that give rise to rights or duties. And this explains, I think, why the idea of regarding a departure from the terms of a jurisdiction agreement as a breach of contract, and as liable to be dealt with as such, which comes quickly and naturally to English lawyers, seems to take many non-common lawyers by surprise. But if one understands the effect of agreements as being jurisdictional only, as working by the creation and grant of a power and the creation and assumption of a liability, there is no duty and nothing to breach. And there are no jurisdictional rights and there are no jurisdictional wrongs. It follows, of course, that the idea of a claim for damages for breach of a jurisdiction agreement is even less likely to be persuasive. And of course, the idea that there is a role for a governing law on this question is redundant. The statute, the lex fori, provides all that one needs to determine whether this jurisdictional power-liability relationship has been created. There is good reason to read the relevant provisions of the Brussels I regulation this way. 6 indications may be noted. First, there is the language of the regulation itself. Article 25 does not ask whether there has been a contractual agreement, just an agreement, and there are, as I have suggested, several substantive ways to agree, or perhaps several strengths of agreement. Second, the agreement is required to take or be evidenced in a particular form, in writing or evidenced in writing. This would be a surprising requirement for a contractual agreement because we tend to reserve formal requirements for contracts concerned with land or other contracts descended from the statute of frauds. But it makes much more sense to require writing for an agreement which is to have a force independent of any contract. To be a little simplistic, perhaps, the formal requirements do the job which the law governing a contract might in another universe have done. Third, there is the relationship with Article 26. Fourth, there is the fact that a judgment from a court in another member state must be recognised and is therefore liable to be enforced, even if that court has adjudicated inconsistently with Article 25, because all the court would have done is err in its understanding of the jurisdictional power and jurisdictional liability, just as it does when it misunderstands or misapplies rules, for example, about domiciliary jurisdiction. That's all. Fifth, there is the way the European Court has tended to deal with the jurisdictional issues in a case in which the substantive rights of a contracting party who has made an agreement on jurisdiction which complies with Article 25 come into the hands of another, whether by transfer or assignment or subrogation or anything like that. If the transferee or assignee is regarded as succeeding to the rights of the transferor or assignor, he is in law the same person as the transferor or assignor, and he steps into the agreement on jurisdiction as well. But if he is not in that sense a successor, he's a sub-buyer, for example, He will be jurisdictionally liable in the way his transferor or assignor was only if he makes his own or gives his own individual agreement, waives his own jurisdictional privilege, assumes his own liability, confers on the other a jurisdictional power by his own act. And the sixth point brings us back to the common law and the relationship between inherent jurisdiction, as the common law understands it, and legislative jurisdiction as the regulation creates it. Where the jurisdiction of a court is inherent, it is natural to accept, as the common law does, that the court has a power which is equally inherent to control the exercise of that jurisdiction. In England it does so not only by reference to a principle of forum non-conveniens in general, but also by paying particular attention to the agreements, the contracts, which parties made with each other to invoke and to not invoke that jurisdiction. Contractual agreements in the common law system do not create jurisdiction. Service does that. Contractual agreements in the common law system do not remove jurisdiction. They cannot prevent service. But they may form an important element of the data by which a court decides whether to exercise the inherent jurisdiction. They form part of the data by reference to which a court decides whether to set aside service and therefore whether to exercise jurisdiction or not. So much for jurisdiction then. Where jurisdiction is defined by legislation, the only question to ask is what the lex fori says, what its legislator has provided for. In the case of the regulation, the material question is whether the parties agree to the jurisdiction of the courts of a member state, the presence of that agreement being tested by reference to the words of the legislation and not by recourse to the private international law of contract. Where jurisdiction is defined as inherent or is inherent, the only question is whether there has been service. In England, therefore, the presence or existence of jurisdiction is unaffected by the presence or absence of contractual agreement. And oddly enough, in this respect, therefore, the common law and the regulation are in alignment. The point at which they diverge is when it comes to the existence, as there is in the common law, or the non-existence, as there is in the case of the regulation, of a discretion not to exercise that established jurisdiction. And it is at this point that the agreement in relation to jurisdiction shows its second side. We move now from the purely jurisdictional effect of agreements to ask whether there's anything more to be said about them. What we should ask is whether agreements made by the parties concerning the jurisdiction of courts are monophysite or diaphysite in nature. It's obvious that an agreement can work at one level and mean what it appears to mean. But it is also clear that an agreement may work not only in the way that its wording would suggest. An obvious example drawn from what we have already seen is the common or garden variety of jurisdiction agreement, as this would have been understood as a matter of common law. Let us take for an example this: the courts of England shall have exclusive jurisdiction over all disputes arising under or in connection with this contract. Now, as said above, whatever else that contractual term may do, it cannot be understood to have created or conferred jurisdiction on the English courts. As a matter of common law, statute may be different, service of process by a plaintiff is what confers jurisdiction on the English court. Being amenable to service is what puts the defendant in a position of being subject to the jurisdiction of an English court, and the agreement of the parties neither creates jurisdiction nor takes it away. But it may form part of the data considered by the court in deciding whether or how to exercise a jurisdiction which the law may give it, and that's a very different thing, and we're coming to that. What do parties actually agree to do when they subscribe to a jurisdiction agreement in terms such as these? Do they say or intend to say, does the language in which they have expressed themselves suggest to the intelligent reader that the designated court has jurisdiction? At least in England it shouldn't do that, where the parties have no power to write or rewrite the jurisdictional rules which regulate access to an English court. But it is possible to read the agreement as the parties having made mutual promises to each other by which each stipulates to the other where he will and will not institute proceedings against the other. In other words, we may call it a jurisdiction agreement but it may be more precise and more illuminating to call it a litigation agreement or a dispute resolution agreement. Now, if this is right, and if the agreement is properly to be interpreted, whatever else it may or may not do, whatever other purpose it may or may not serve, as making and taking promises as to where proceedings will and will not be issued, it is not difficult to understand why an English court will see such an agreement, or this aspect of an agreement, as a contractual term, as part of the larger bargain between the parties and as susceptible to judicial enforcement just as any other term of their contract is. May take it into account as part of the material by which they decide whether to exercise a discretion to exercise or not exercise jurisdiction, or as the basis of a claim for relief for breach of contract, for example. And if it is argued that the parties have made an agreement with each other to behave in a particular way, and if it is alleged that one of them has breached the terms of that agreement so that the other has a right to relief against the other, the substance of that allegation can be tested only by reference to the law which governs that agreement or that aspect of the agreement. Whether that agreement has any effect on the jurisdiction of the court is a matter for the lex fori to say, and for no other law. But whether the agreement was contractually binding on the parties dictating the way they would behave is a matter for the law governing the contract in which that promise was made, and for no other law. And there is no conceptual difficulty about the idea that parties to a contract may make an agreement which stipulates how they will behave in relation to each other. Consider it this way. Suppose the parties had said, the parties agree that in the event of disputes arising out of or in connection with this contract, no legal proceedings will be instituted against the other unless these are legal proceedings before the courts of England. Such a provision says nothing about the judicial jurisdiction of courts. Instead, all it does is state or record an agreement as to a specific aspect of personal behaviour. It's very hard to imagine that an agreement cast in those terms will be difficult to enforce, prospectively by specific relief, retrospectively in damages, because if I promise not to do something and then I go and do it, I can hardly claim to be surprised when I am sued on account of that particular wrongdoing and required by the court to undo the wrong. So does the short form clause, which I mentioned earlier, actually contain a promise in terms of the kind mentioned above? Now, this is a question of construing the meaning which an intelligent party would take the words in their context to convey, but my answer would be that it does convey such a promise of good behaviour. If it is objected that it doesn't do so in express terms, the proper response is that this meaning or amplification is latent in the words or is liable to be inferred from them. And if anybody were to ask whether the first of these two sentences meant or also meant that no legal proceedings will be instituted against the other unless these are legal proceedings before the courts of England, the answer would be yes, of course, obviously. And there is judicial support for reading an agreement as to how and where disputes will be resolved as being diaphysite in nature. In the judgment of Lord Mance in the Supreme Court of the United Kingdom in the Camanogorsk case in 2013, the clause with which the English court was directly concerned was an arbitration agreement. The problem was that the proceedings with which it was concerned were judicial, or said to be judicial proceedings before the courts of Kazakhstan, where something very strange was going on. The positive agreement to arbitrate, said Lord Mance, is one thing, but the negative agreement not to bring proceedings in a court, even if the other side of the coin, is another, as he said. An agreement to arbitrate disputes has positive and negative aspects. A party seeking relief within the scope of the arbitration agreement undertakes to do so in arbitration. The often silent concomitant is that neither party will seek relief in any other forum. In each case, the negative aspect is as fundamental as the positive. Now, that insight, that there are two distinct agreements liable to be distilled from one form of words, seems to me to be helpful in the present analysis. It is the reason why, when a party applies to court for an anti-suit injunction, the court is not enforcing the positive agreement to arbitrate, but the other, the negative, often silent obligation not to sue before the courts of another member state. This concomitant obligation may be silent, but it is just as much part of the agreement as are the express words, and if it is there, there is no good reason not to enforce it. So with that very long introduction behind us, let us then move to the case in which the parties agree in short form that the English courts are to have jurisdiction, or to have exclusive jurisdiction, and how this form of words is to be understood in the context of a case in which the jurisdiction of a court is defined by the Brussels I regulation. There is now a rule of English statute law made by the competent legislator that where the parties have made an agreement such as will fall within Article 25 of the regulation, the English court will have jurisdiction. If they subscribe in proper form to an agreement in these terms, the courts of English will have exclusive jurisdiction over all disputes arising under or in connection with the contract. The question is, what meaning can be extracted from those words? First, as to jurisdiction. The effect of this form of words is that a defendant who may be domiciled in a member state other than the United Kingdom and who is therefore born with the privilege of being sued only where he is domiciled, agrees that the other shall have a power to sue him in the designated court, and so agrees to be liable to be sued there. That is the jurisdictional effect of the words used, as Article 25 and the general scheme of the regulation tells us to understand them. If proceedings are brought in the English court, the defendant cannot be heard to say that the court does not have jurisdiction. If proceedings are brought before the courts of another member state, that court will see the designated court as having exclusive jurisdiction and will dismiss the proceedings before it. As the European Court has explained, the assessment of these jurisdictional contentions does not depend on or even look to a governing law. The regulation itself, and in particular Article 25, is the governing law. The question is whether these words mean that the court has jurisdiction is a question for the lex fori and for no other law. Second, as to litigation behaviour. The effect of this form of words is also, as is submitted, that each party made a contractual promise to the other not to issue proceedings before the courts of a country other than England. If in spite of that promise, one party to the agreement were to go and institute proceedings in a court outside England, by doing so he would breach that promise, doing the very thing he promised not to do. This, as I see it, has nothing to do with the question of existence or non-existence of judicial jurisdiction. This promise has no concern with, and certainly does not ask whether, the foreign court had jurisdiction according to its own laws. If the foreign court had jurisdiction under its own law to adjudicate, the plaintiff breached his promise by going there to sue. If the foreign court did not have jurisdiction under its own law to adjudicate, the plaintiff breached his promise by going there to sue. It's all one and the same thing, and that one thing is breach of a promissory obligation. And if there is to be an allegation that a contractual promise has been broken and relief is sought on the basis of it, this promise must be assessed by reference to the lex contractus, the law which governs the contract in which it was or was said to be contained. This is why English courts are justified in treating agreements relating to the jurisdiction of courts as being or as containing contractual terms which can be broken and which can be dealt with by injunction or by an award of damages. It is not the so-called agreement on jurisdiction which provides the basis for relief, but the concomitant, possibly silent, implied agreement not to issue the proceedings which were issued elsewhere, which provides the cause of action. There is therefore no sound basis for a suggestion that an English court is concerned with the judicial functions of the foreign court. There's no suggestion that the English court is considering, still less ruling on, a foreign court's judicial jurisdiction. And the conclusion which all this leads me to is that every jurisdiction agreement or forum selection clause, the question of terminology is interesting but perhaps ultimately peripheral, has the potential to do two things. It will provide the data by which the common law or the statute tells a court whether it has jurisdiction, and it will say whether there is an obligation laid on either party to issue or refrain from issuing proceedings. If the question is then why the common law has tended to see or tended to treat these as contractually binding provisions, while the civil law perhaps does not do so, it may be because the common law is really focusing on the second, the private and bilateral aspect of the agreement and considering what to do about it, whereas the civil law systems tend to concentrate on the first, the public and jurisdictional aspect of the agreement and to stop there. And this may be why the civil law, for which the Brussels regulation is a representative, does not look on jurisdiction agreements as being subject to a proper law or the governing law of a contract, but why the common law, when it asks some rather different kinds of question, does. Now, if time had permitted, we could have conducted a similar kind of analysis in relation to agreements on choice of law. We could ask ourselves whether there is anything promissory in a contractual term which states that a court is to have exclusive jurisdiction over a dispute, as saying that the parties come to a conclusion that says they would like this court to adjudicate or not. But if they choose to come up with a different form of words, which says a contract is governed by a particular law, what are they saying then? How should we interpret a term in a contract which says a contract or a trust or something like that, some relationship, is governed by a particular law? Now, the question whether a contract or trust is governed by one law or another will be determined by rules of private international law, whether these are common law or statutory. And the source of authority on the question what law governs a contract or a trust is the private international law of the court which has been seized and nothing else. These are rules of private international law, and if they pay attention to what the parties have agreed or said they agreed, the law thus identified may be the law which the parties have chosen. But whatever the answer is, the expression or choice of agreement by which the parties say what law they would like to have govern their contract is not promissory, but is a statement that the parties were ad idem as to the law which, as far as they were concerned, should be applied by the court. Evidence of this agreement may be put before the court which is asked to give effect to it, and it may mean that one party has a power to plead that this is the law that governs the contract, the other has assumed a liability to allow him to do so. It may be a term of the contract, but insofar as it seeks to influence the decision on what the governing law is, it may not be promissory. It may then be that there is a second distinct aspect to this kind of agreement as well. Because what really matters when the parties are in dispute is for the parties to bring their dispute before a court which will act in accordance with their agreement as to how the law is to be applied. If it is viewed in this light, an agreement on choice of law may be seen to be promissory, in that it promises behaviour in litigation of a particular kind. If we take the view that the clause does not purport to tell the judge or the court what law governs the contract, it may be that it records an agreement that the parties told each other that their disputes were to be determined in a particular way, that they promise each other how, as distinct from where, their relations will be adjudicated, so that one may say the jurisdiction is an agreement as to where, and an applicable law and agreement is a promise as to how the parties will seek the resolution of their dispute. It seems to me that the parties making a choice of law agreement may be held to so promise. And if that much is arguable, then the only question which remains is whether it can be extracted from a bald, perhaps somewhat gauche statement that a contract is governed by a particular law. Does that also contain a promise that neither party will take a step to undermine or frustrate or prevent the carrying out of the agreement, that this will be the law which is used to regulate their relationship? It seems to me that that is a perfectly sensible position to defend, and it's a perfectly plausible promise to make. And if one were to ask whether it meets the implication test of necessity or obviousness, there is no real reason to doubt that it does. And if that is so, then one may say that although a choice of law clause in a contract is not itself promissory, so far as concerns the identification of the governing law, it may separately allow a perfectly realistic promise to be implied, and for that promise to be dealt with as such. And if that is so, it is possible for an agreement on choice of law to be seen as doing two things: as making a statement to the court as to the parties' common expression of intention as to the governing law, but also as making promises to each other about the way and therefore the place in which their dispute will be dealt with. It's fair to say, one must freely concede, that this is a conclusion which has found no real judicial acceptance. But the caution of judges is no reason to doubt the wisdom of the law, or to impede the legitimate expectation of commercial parties who make agreements to bring about results which seem important to them. The law is perfectly capable of giving effect to such things, and there are occasions on which it should. And I should now like, if I may, to skip a little more and just try and draw some threads together. There is no doubt that the tradition of private international law has been to see the subject as being underpinned by its own doctrines of comity and so on, and not as being a code which the parties write for themselves. After all, we're speaking of law here, not arbitration. It's not surprising that there is sometimes resistance to the idea that the parties may, by contractual agreement, create and impose obligations on a court which the court must accept, or on each other which the court must, if asked, enforce. But if and insofar as a contract has a promissory nature, and it can be shown to have been breached, it is hard to understand why the common law of contract should not be used to secure its performance. The question of remedy will be separate, for some remedies for breach of contract are discretionary, but contractual promises generate contractual rights. If this is right, then there is no need to accept that the common law approach to agreements on jurisdiction and their enforcement is irreconcilable with the view which the civil law in general, or the Brussels regulation in particular, seems to take of jurisdiction agreements. Such clauses or agreements may operate at two levels or have two lives, only one of which may be material to the judge who has to decide whether his court or her court does or does not have jurisdiction, or whether a contract is governed by this or that law. He may not be concerned with promises that the parties made to each other. But the other level, by which the parties assume duties and grant correlative rights to each other, stands apart. And it cannot be said, surely, that the existence of one interferes with the other. Where the jurisdiction of an English court is regulated by the Brussels I regulation, whether there is an agreement for its jurisdiction or for the jurisdiction of the courts in a member state is therefore answered by the lex fori, which means by the regulation without any recourse to any other law. It's not answered by reference to the law which may in due course be found to govern the contract of which it was a term. The European Court has made this clear, and we now understand why that is a good and sensible solution. But where the parties have made an agreement which is valid and binding according to the law which governs the contract of which it is a part, that proceedings will not be brought in the court before which they are being or have been brought. That's a breach of contract. And in principle, the usual remedies for breach of contract are available unless these have been removed by a superior law. Where the jurisdiction of an English court is regulated by the common law, service of process is what gives the English court jurisdiction, and there is neither room nor need for any other kind of agreement. But if an application is made to the court that it exercise its discretion to stay the proceedings, that application may well be based on the contention that the parties made an agreement valid and binding according to the law which governs the contract of which it is a part, that proceedings will not be brought in the English court. That is a breach of contract, and the usual remedy for such a breach of contract is a stay of proceedings. To make the same point in another way, we need to be clear why the question of agreement has arisen so that we can refer it to the proper part of our rules of private international law. 1. If the basis for or existence of jurisdiction in the court seized does not depend on the creation of rights and duties, as under the Brussels regulation it does not depend, and as under the common law it does not depend either, the court will simply apply its rules of jurisdiction, the lex fori. There will be no need to inquire by reference to any contract between the parties, and therefore by reference to any law governing the contract between the parties, whether there was a legally enforceable agreement to sue in any particular court. 2. If the lex fori finds that there is jurisdiction, but also regards as admissible, as the common law does and the Brussels regulation does not, a contention that the parties assumed rights and duties to each other not to sue in the court seized, the substance of this contention must be assessed by reference to the contract between the parties and therefore by reference to the law governing that contract, to the lex contractus, to see whether it is soundly based. When the answer is arrived at, what happens next is a matter for the lex fori and for it alone. 3. If relief is otherwise sought, such as an injunction, for example, to restrain conduct of which complaint is made, or damages for failing to act in accordance with a contractual agreement, the claim being based on the contention that the parties assumed obligations, rights and duties to each other not to sue in the court, sees the contention must be assessed by reference to the contract between the parties, and therefore by reference to the law governing that contract, the lex contractus, to see whether there is a good cause of action for the relief sought. If there is a good cause of action, according to that law, the court should grant relief. 4. If the parties have agreed that their contract should be governed by a particular law, it will be for the court seized of the litigation to determine in accordance with its rules of private international law whether the agreement is material or immaterial to the identification of the governing law. If the court determines, last point now, that the contract is governed by a law other than that on which the parties had agreed, but if it is also alleged that in bringing those proceedings one party acted contrary to the promise which the parties had made to each other, that contention must be referred to the law which governs the contract, the lex contractus, to see whether there is a good cause of action for relief. If there is a good cause of action for relief according to that law, the court should grant relief unless a particular provision of the lex fori overrides it. And for that reason, it seems to me that a sensible way of sorting out the many consequences, or the many effects and many consequences, of an agreement on choice of law and an agreement on choice of court depends upon our asking ourselves, first of all, are we inquiring as to whether there was an agreement for the purposes of jurisdiction, or are we inquiring as to whether there was an agreement for the purpose of saying somebody is acting contrary to his contractual promise, as a result of which certain judicial consequences may follow? And that's why it seems to me that these agreements on choice of court and possibly also on choice of law are dual in nature, and that their particular consequences may not all be governed, indeed will not all be governed, always by one and the same law. I'm sorry for the scramble that represented, and for the fact that at some point in the middle I seem to have lost my way. I don't quite know how I did that, but I did it. If anybody finds it sufficiently interesting to go back and want to see slightly more slowly what I said, I gather the paper is posted somewhere, and if you agree with it, I'm happy, and if you disagree with it, I'm happy too, because all this is in the nature of material which helps us discuss and therefore learn. Thank you for your attention. I'm very grateful.
Thank you very much, Adrian. We have quite a goodly number of people on listening in on this, so hopefully they will send us some questions while Simeon is discussing your thoughts and adding some of his own. Just as a reminder / correction, I had indicated the wrong way of conveying questions. If those who are on the line have a question for Adrian or eventually for Simeon, please send an email to events, that's the plural of event, at acil.org. So with that, I will hand it over to Simeon.
Thank you, Stacy. Thank you, Professor Briggs, for this very insightful and enlightening presentation. I think your description of jurisdictional agreements as being of dual nature and dual effect makes perfect sense to me, and I believe it is consistent with the way American courts would view these agreements, although one cannot find any cases that put the matter in quite these terms, or especially that discuss the issue with the depth of understanding that your presentation exhibits. If we had more time, it would be nice to be able to, and I do like very much the way you reconcile the English common law with the Brussels I regulation. And I would remind our American viewers, by the way, that now, as a result of the recast in 2012, the Brussels regulation applies to defendants domiciled in the U.S., which means your own clients, guys. So this is relevant to what to practicing lawyers in this country. I wish we had time to really discuss some aspects of Article 25 of Brussels I, especially the reference that Article 25 makes to the law of the member state of the chosen court. We debated that phrase for a very long time. I happen to be a member of the working group that drafted the recast, and later the chair, in fact, of that group. And we discussed that for a long time. We intended to make Brussels I parallel to the Choice of Court Convention, where the phrase "the law of that state" includes the choice of law rules of that state. So it's not necessarily the substantive law of the forum that will eventually apply. It will depend on the choice of law rules of the forum state, which in some instances may refer to the law of another state, including the lex contractus. But anyway, now I'm not sure. Speaking now from the American perspective, I'm not sure that the monophysite or diophysite nature of the forum selection agreement, and as far as American law is concerned, makes much difference in terms of the remedies. But it perhaps should make a difference in helping us resolve the question on which American courts are very divided, which is what law governs the enforceability and the interpretation of forum selection agreements. I need to think that through. But maybe that is a way to reconcile our otherwise irreconcilable cases. Now, as far as choice of law clauses are concerned, I doubt very much that the American courts will accept the second part of your description, that is, that they will see in choice of law clauses a promissory part by which the parties pledge to each other to behave in a certain way, not to undermine the court selection of the designated law. And it may well be because in the United States, party autonomy was never as unrestricted as it is in England, or even under Rome I. Party autonomy from the very beginning, 1825 in this country, was subject to, of course, the public policy limitations, but the public policy limitations of not only the lex ori as such, but, and here is the difference between American law and much of the rest of the world, the public policy or similar limitations of the lex causa, namely the law of the state whose law would otherwise be applicable in the absence of a choice of law clause. So we have this dual limitation, and that is why we would not see in a choice of law clause the promissory part, the behavioral part. And in terms of actual cases, as a practical matter, I have seen hundreds of cases in which the party that drafted the choice of law clause argues against the clause. It happens all the time, bad drafting on the part of the lawyer and so on. And I have never seen a case where the other party even make that argument that somehow this is inappropriate or especially that is sought to obtain sanctions against the drafter of the clause, who now changed his mind and is arguing against the clause. But anyway, if I did have some time, I would like to talk a little bit about how American courts address the question of what law governs the validity and enforceability and interpretation of forum selection clauses. And I have posted my paper. I hope people who are interested may have access to it. And I distinguish between two situations, as the Hague Convention does. Number one, where the action is filed in the court designated in the forum selection clause. And number two, where it's filed in another court, as one party reneges and sues in another court. And in the first scenario, where the action is filed in the chosen court, American courts apply the law of the forum as such. They don't look to the lex contractus and so on. And that is really the easy scenario. The difficulties are when the action is filed in the non-chosen court. There I distinguish between situations where the contract contains a choice of law clause in addition to the forum selection clause, and cases where it doesn't. So, and the most difficult situation is where the contract contains a choice of law clause in addition to the forum selection clause. In those cases, the courts are really divided. Many of them apply the law of the forum without any inquiry as to the choice of law clause. Some courts recently have begun making the distinction between issues of interpretation of the forum selection agreement, for example, whether it was mandatory or permissive, or whether it encompassed certain types of claims, delictual in addition to contractual, for example. And for those, they apply the law chosen in the choice of law clause. And for the rest, that is issues of enforceability, they apply the law of the forum as such. No cases apply the law of the state whose courts are chosen in the forum selection clause. So looking at all the cases, the prevailing practice in the American courts is to apply the law of the forum for most issues in most cases. And frankly, I don't think that's a bad idea. Because and I have a number of reasons for that. Number one is that unlike the law of most countries, American law does not accord a priori protective treatment to certain weak parties like consumers, employees, insurers, franchisees. Therefore, these parties are particularly vulnerable. And by applying the law of the forum, and remember, I'm talking with cases for cases in which the action is filed in the non-chosen court. Yeah. Allowing that court to apply its own law is a safeguard that these parties need for the situations in which the other contracting party, the corporate defendant, cleverly combines a forum selection clause with a choice of law clause to give itself the best of both worlds. Yeah. The application of the law of the non-chosen court in that situation is the only safeguard that the weak party has to get out of that kind of clever combination. Forum selection clauses are of a peculiar nature in the sense it is true that, as the Supreme Court said in Bremen versus Zabada, that it is a vestigial fiction to say that they oust the court's jurisdiction. As Professor Briggs said, a court's jurisdiction is another matter. It's not based on the agreement of the parties, therefore it's not ousted by the agreement of the parties. That is true. Nevertheless, a forum selection clauses, or when a court chooses to enforce a forum selection clauses and dismiss the case, or send them elsewhere, transfer the case or whatever, the effect of that is that the court doesn't hear the merits of the case. And so in a certain sense, the end result is we don't hear the case. It's like we don't have jurisdiction. Therefore, I believe that the law of the forum, that the forum state has a right and perhaps a duty to decide under its own notions of justice and conscionability or whatever, whether this case should be heard here rather than elsewhere. So in that sense, although I'm not generally a fan of what is known as the homeward trend, that is applying the law of the forum at any cost, so I don't generally subscribe to that philosophy. But when it comes to the issue of the enforceability of forum selection clauses, I prefer to err on the side of applying the law of the forum rather than the law chosen in the clause or some other law. And that is all I have to say within the time allotted. And I will now shut up and listen, and if we have any questions and so on. So, Stacy, back to you.
Thank you very much. I feel like we're doing a newscast, kind of who's the reporters and who's the anchor. I'm not saying I'm the anchor.
You are the anchor.
I would say, rather than looking at the questions, because they're a little bit diverse and we are running out of time, I would put it to Professor Briggs. Do you have any response to Professor Simeonidis' thoughts?
Oh, as he says, if time was unlimited, there would be so many interesting things to say. And what it goes to show, at a very general level, is that each legal system struggles between a system in which jurisdiction is established by rules of law and a sense that the parties should have some freedom, and we strike the balance in different places for different purposes. And I think that's probably as true as between the common law and the Brussels regulation at home. I'm sure that a different set of balances have to be struck within and beyond the United States, but it's the same exercise in the end, trying to measure and limit the extent to which the parties can prescribe for themselves in the end which court would adjudicate, whether it does it by defining jurisdiction or giving grounds for not exercising jurisdiction which the court will be sympathetic to. On the question of choice of law, though, and whether these provisions are promissory, I entirely agree with my colleague that it'll be a long time before a court is persuaded that they are. But if I draft a clause in a contract which says the parties agree that proceedings may be brought before any court which will apply this country's law to the resolution of the dispute, what I seem to have done is engineered a situation which looks like a jurisdiction agreement, a statement about where proceedings may be brought, but which is not described in geographical terms, but is defined by reference to what the court will do. And if I can say, well, if I can put that kind of provision into a contract, and then say that if my counterpart sues in a court where this is not what happens, he breaches his promise. And it seems to me then that if I were to try and make my argument to convince somebody who was not convinced, what I would do is start with a jurisdiction agreement, and then I would change it little by little so that it gets into the territory where it is in form a jurisdiction agreement, but is in effect an agreement as to the law which will be governed. And then I take another step and another step and another step, and in the end I think the conclusions I come to is that there is not as sharp a distinction between these types of provision which parties may put in their contracts as we tend to assume when we explain this to students, because we have different sets of rules for this kind of clause and that kind of clause. So it seems to me that there is, if one wanted to do it, one would explain to the court, well, look, you'll be prepared to give effect to this kind of promise, and if you would do this, you would give effect to this kind of promise, and if you would do that, you would give effect to this kind of promise, and before we know where we are, we've reached the point where the court says, yes, we can see that you made a promise as to the law which will be applied by the tribunal before which you brought proceedings, and however you've managed to do it, you have not acted in accordance with that promise. And so I suspect there is a really interesting argument to be had there. It may be it will be after I've packed up and finished work, but I think it can be done. But otherwise, I just learn an enormous amount from listening to and reading what my colleague has to say on questions which are recognisable to us, but we have a different legal framework within which to deal with them. All I think that one can say is that the task for an English lawyer is really to explain English law to English lawyers, because we tend not to think very carefully about the reasons that our courts do things. And one of the brilliant things that Brussels regulation has done is give us an opportunity to sit down and think again about what it is that agreements on jurisdiction really do. Without that stimulus, I think we would never have done any of this. We would have continued to say, these are simply contractual terms, and because that's what they are, we will treat them as contracts. And then somebody says, well, actually, there are other ways to agree. And the moment you realise that that's true, a whole separate avenue of analysis is opened up. And that's why it seems to me that the most useful thing an English lawyer can do is talk to someone who's not English in order to get another insight into the problems that English law faces, the better to understand his own law. We don't make any progress in England just by talking to ourselves.
I could not and we have a couple questions in the queue, and I have a couple questions of my own that I would love to ask vis-a-vis the possible effect that this new formulation of how to consider form selection clauses / agreements on jurisdiction might affect the arbitral realm, and whether parties might now start to say, well, let's just breach the arbitration agreement and either pay damages or try to deal with it in some other way. Unfortunately, I think that we don't have time, which is in ways good because it inspires a lot of people either to read your article and then write their own articles in response, or in other ways get their thinking out. Would both of you please let us know where we can find the expanded or final versions of your papers, because I know one is an excerpt and one is a work in progress.
I will have another go. There won't be much more to do at this stage. Whether it gets written up elsewhere, I'm not currently sure, but I've some tidying up to do. I noticed some things as I went through which I would like to tidy up. So I will aim to send that back to Stacey in a week or two, so that the American Society of International Law can have it if it wants it. I'm very happy that it should have it if it would like to. I would also say, if anybody had questions which, because of my exceeding my time allowance, they didn't get a chance to put to me, they are more than welcome to send them to my email address in Oxford, and I'll try my best to respond by email. I'd be really happy to do that, because there has never been a question which a lawyer has asked me which has not been useful and made me think. So if anybody wants to send emails to adrian.briggs@law.ox for Oxford, AC, academic.uk, law ox uck, please feel free. And my apologies for having spoken for too long and prevented the people who sat patiently and attentively from getting their questions put in. I apologise for that, but sometimes you get carried away with excitement. This was one of those occasions.
No apologies necessary. Ready, as I did every word that both of you spoke. Simeon, do you want to let us know where you're?
Yes. Yes, first of all, it was a pleasure listening to Professor Briggs. I wish we had more time. I wouldn't mind listening for another hour. Secondly, yeah, the same goes for me as far as questions. My email is very easy, simeon@willamette, that's my university. Nobody can pronounce it correctly. It's like my last name. At Willamette EDU, Simeon@Willamette EDU. I would be glad to entertain questions, if any. My paper is an excerpt from an upcoming book, which should be out in a couple of months. It's Oxford Commentaries on American Law, Choice of Law. So it should be out. It's already in page proof stage. I think in a month or two it may be out. So look for it, and if you get your library to buy it, so much the better.
So Oxford, both the press and the university would be very pleased with all of the references that are going out here, but I know that both of you have other obligations to get to. So again, on behalf of the American Society of International Law, on behalf of my co-chair, Cristian Jimenez Corte, I would like to thank you both for your fantastic presentations and insights which you've offered to us. So thank you, and have a good rest of the day.
Good afternoon. Good afternoon. Bye-bye.
Thank you. Bye-bye.